Hi everyone, and welcome to the third installment of This Week in Immigration, where we're helping you make sense of the big stories in immigration policy. I'm Jordan Lapierre.
And I'm Hunter Hallman. We'll get you up to speed on what matters in 30 minutes or less.
You can subscribe to this podcast and all of BPC's podcasts on iTunes, or stream on our website at bipartisanpolicy.org.
And while you're there, you can find about all the topics we discuss on the podcast. Just go to bipartisanpolicy.org/immigration.
On the podcast this week, is the DACA deadline real? The worsening backlog in immigration courts, and comparing merit-based and family-based immigration systems.
Let's start with the DACA deadline. The program is set to expire on March 6th of next year if Congress doesn't act. But how real is that deadline? Theresa Cardinal-Brown is here as always to explain. We've spoken before on the podcast about the Trump administration's decision to end the DACA program after a 6-month wind down on March 6th. But we've also heard some recent conflicting things about that deadline. So is DACA really ending on March 6th?
Well, technically DACA has already ended. For anybody that had status that would expire after March 5th, they were not able to apply for any extensions. And for those who had status that would have expired before March 5th, the time period they could apply for extension has passed. So as of right now, no new applications for DACA are being accepted, no renewals are being accepted, and anybody who has DACA status is on a clock until their current status expires. So technically there is no DACA program. But what we heard when President Trump, the administration announced the end of the program, he did give us this 6-month period. He asked Congress to do something in that period. But that same day he tweeted out that if Congress doesn't act, he might revisit the issue. And this week we heard something from a Republican senator, James Langford, who's one of the sponsors of a Republican bill on Dreamers in the House, the Succeed Act, that he heard from President Trump again that the president might extend the deadline. What that means in reality, we don't exactly know. The program has existed, is done. It's terminated. USCIS, the agency that processed all of these applications, is no longer processing anything. And so even if they were to extend the program or reinstitute the program is really what they'd have to do, there'd have to be a ramp-up process for the agency to be able to do it again.
So obviously a group that's watching these ongoing conversations closely is current DACA recipients. How are they being impacted by the discussions?
Well, those who have DACA right now, as I said, are on a time clock. They know right now when their status is going to expire, and they're trying to figure out what happens next after that. Because when their status expires, not only are they not protected from deportation, but their existing work authorization expires as well. So many of them are in the position of losing jobs. Maybe they've enrolled in college, and maybe that enrollment could be in jeopardy if they lose their DACA status. Many of them obtain driver's licenses and other state IDs based on the fact that they had a government-issued document that may or may not be able to be renewed. So it's impacting every aspect of their lives right now. And a lot of them are trying to figure out what happens next. The fact that at some point in the future the program may be extended or reinstituted is not helpful if they don't have any solutions soon.
Will current DACA recipients be able to take advantage of any kind of extension that we know of so far?
Well, again, there's no extension now. This is all, basically speculation based on a couple of tweets and a secondhand conversation with a senator. So I wouldn't advise anybody to take action on the grounds that it might be extended anytime soon. That having been said, as I mentioned, there are operational considerations for the government when a program winds down and when it renews or resumes. So USCIS is processing those applications they have in their queue right now, but once they're finished with that, they will no longer process any more applications. And so the adjudicators who are doing that will move on to other types of cases. If the government, the administration, decides to reinstitute the program, then USCIS would once again have to ramp up. They'd have to issue new notifications. They'd have to decide whether or not people who were eligible could reapply now if their previous status had expired.
Yeah.
All of those decisions would have to be made, and there's an awful lot to do. So even if the president decided on March 5th, for example, okay, I'm not going to let it end, I'm going to reinstate it now, it could be a couple of months before the agencies know how they're actually going to do that and who it's going to apply to issue those directives out. So again, operationally, you can't just turn a switch on or off like that.
So in other words, it hasn't ended until it's ended?
Well, it's ended, but it can't be restarted immediately. And there's no, I think, sense right now that the administration is definitely going to reinstitute. I think right now the focus is where it should be, and that's on Congress. Because at the end of the day, any administrative program that the Obama administration or the Trump administration were to put in place to protect these people is not a permanent status. Congress is considering legislation right now that would grant them a permanent status, and that's really the solution that's necessary. Frankly, I don't think Congress should wait till March 5th. As I mentioned, everybody in this situation is dealing with real-life consequences right now. They really should deal with this as soon as possible, preferably by the end of the year.
So to pick up on that, as we know, Congress is working on a permanent legislative fix right now. What do you think all this shifting narrative means for those efforts? Do you think it makes it easier or harder?
Well, we know that Congress works best when it has deadlines. And so some of this may be a sense of trying to say that the deadline isn't as soon as December. The deadline is really in March. But I think that doing that, or if anybody in Congress is feeling like they have more time to do it, that actually makes it less likely that they will come to an agreement and get a solution done. So I think we at BPC have absolutely been urging them to try to come up with a solution, try to pass legislation as soon as possible this year.
Great.
For our next conversation, I'll turn once again to my co-host, Hunter Hallman. She's been diving into the immigration court backlog, how we got here, why it matters, and what to do about it. Hunter, first, please explain for me what the immigration court system is. If you're apprehended as an undocumented immigrant in the United States, you go into this system, but what happens next? How is your case heard?
Sure. So first of all, there's kind of two options for once an immigrant is apprehended. Either they can be removed by expedited removal, which does not appear before an immigration court judge. And that applies to immigrants who meet a certain set of criteria upon apprehension, or if they've been previously deported and re-enter, they can qualify for expedited removal. Second of all, if you're not qualifying for expedited removal, you do go before an immigration judge. And Department of Homeland Security, DHS, will issue a notice to appear for an initial hearing, at which point your court date is set on the master calendar. And once that court date is set, what's up next is the individual hearing, and that's when the immigrant will plead their case to the immigration court judge. Right now, it stands at over 600,000, and that, I believe, is double from 2011 and triple from 2009.
How did it get this bad?
So it has always been pretty steep, but I think especially the 2014 surge of children and families at the border really subsumed the courts. The just sheer number of children and families who were arriving and claiming asylum really backed up the court system.
So what is the Trump administration then doing to try to address this problem? It's obviously something that needs pretty immediate and significant attention.
So first of all, as I mentioned, expedited removal processes, they have expanded kind of the criteria for who can be removed in an expedited process that does not come before a judge. So it used to be that the Obama administration's priorities said that if you were apprehended within 100 miles of the border, and could not prove that you'd been in the country for 14 days, that was what qualified you for an expedited removal. Now it's anywhere in the country, and you have to have been able to prove your presence for 2 years. So that really has expanded the pool of people who can be expedited without going before a court. The administration has also added about 125 new immigration judges over 2 years, 2017, 2018. But according to estimates, that would really only reduce the backlog after about 6 years of them being in place. And finally, they've redeployed a significant amount of immigration judges to the southwest border where most of the cases are. So, for example, they've taken about half of the judges for immigration courts in New York City and put them at the southwest border.
Is that going to actually solve a problem, or is it just sort of moving around the deck chairs? I mean, it sounds like maybe that's taking resources from one place that might need them and putting them in another place which might solve part of a problem, but not all of a problem.
So I would agree with you. I think it kind of remains to be seen how that plays out in the long term, but I will say that there's already 80,000 cases backlogged in New York City alone, so having half the amount of immigration judges you had before is only going to contribute to that problem, and it's kind of unclear how that could really help a 600,000 case backlog overall.
So to that end, the Washington Post just published an article about the administration's plans to change case quotas for immigration judges. What does that mean, and would that address some of the problems you just mentioned?
So again, I don't know how this is going to play out long term. Jeff Sessions, Attorney General Sessions, has said that these quotas will restore integrity to our immigration court system. I guess more of a accountability process will be put in place, but I can tell you that immigration judges and immigration lawyers are both very unhappy about this. They're saying it encroaches on judicial independence. They're saying it's turning judges into just an assembly line of cases, and unfairly faults judges for the backlog.
Yeah, this is a system that's already pretty taxed as it stands.
Yes, very taxed. I think as before the immigration judges were added these past couple of months, there were only about 300. So President Trump has asked for funding to double that number, but it's just not clear if that's going to be able to happen or not.
Okay, thanks, Hunter.
No problem. To close out the podcast, I'll welcome in Cris to discuss the differences between merit-based and family-based immigration systems. The term merit-based was in the news a lot earlier this year when the RAISE Act was announced, but what does that mean?
So basically, when we're talking about different types of immigration systems, it's important to understand that countries have different types of systems. And these systems have arisen from a range of different factors. It could be something as cultural or sociological. It could be political. It could be institutional. And these have all given rise to a range of immigration systems around the world. But when we're talking specifically about merit-based systems, we're talking about systems that exist. Primarily, people talk about Canada and Australia and New Zealand, but other countries such as Japan have adopted them, where essentially there is a system for permanent immigration where points are assigned to an individual skills base that then, if they're able to have enough points, for instance, I think having like an advanced degree and all that, gives them enough points to be able to then move to the country on a permanent basis and be able to work there as a result. So this is what you broadly know as the merit-based system.
So what does the U.S. immigration system look like now? Is it merit-based, family-based, or both?
So I think that in order to understand the U.S. family system, it's essentially, there are 4 channels to become a legal migrant. You can either do family sponsorship, you can do employment-based immigration, there's also refugee and asylum status, and there's a diversity visa lottery. But the 2 main channels are family sponsorship and employment-based. And so with family sponsorship, it's pretty straightforward. If you're a citizen, you can sponsor your family members to become LPRs. There are, for certain categories of family members, there are a limited number of green cards, primarily spouses, children, and parents of U.S. citizens, and there's also caps for other categories of family members. But there is the employment-based system, but that isn't necessarily what you would call a pure merit-based system. The employment-based system basically allows individuals who are working in the U.S. under temporary visas. The one that you hear frequently is the H-1B specialty visa for specialty occupation workers, where they're able to adjust their status, be able to become citizens. But that process is that they've already received that visa to be able to work in the U.S. based on requirements, and then once they're in the U.S., their employer has to petition them for them to be able to adjust the status. So in order for them to come to the U.S., yes, they need certain skills, but this isn't based around point systems that you would see in Canada, Australia, or New Zealand. So in that sense, we don't have a merit-based system.
So how do those channels you mentioned differ in terms of visa numbers and requirements?
So the global caps for number of visas is 675,000 across all categories. In family-based immigration, there are no caps for if you're a citizen for immediate relatives, primarily spouses, unmarried children under the age of 21, adopted children, and parents of U.S. citizens. And there are caps for other family-based categories, and this is just 226,000 per year. Now, in the employment-based system, there's a total of 140,000 visas for this category. And what you see in the stats is that a lot of these are allocated to H-1B visa holders. 77% of all employment-based green cards go to these individuals. And so that sort of gives you a good sense of the caps. Particularly with the employment-based system, in order to be able to get those visas, employers have to go through a whole process in order to go through this. But primarily that's getting a certification from the Department of Labor that there aren't any available U.S. workers who are willing to work in the sector. The employer petitioning the foreign worker to be able to work there, and then subsequently the foreign worker being able to adjust the status based on the availability of visas, among other things. So those are a good understanding of the caps and the requirements, at least being able to become a permanent citizen, a legal permanent resident in the U.S.
How does the family-based component of the U.S. immigration system set us apart from other nations?
If you look at it in the global context, the U.S., according to the Organization for Economic and Cooperation and Development, also known as the OECD, ranks the U.S. first in family-based immigration and 17th in employment-based immigration among the 23 countries that form the membership of the OECD. It's actually important to also know that France, Ireland, and Korea actually also have high levels of family-based immigration as well. But once again, this directly puts us in contrast with, like I said, more merit-based systems that tend to promote merit-based and economic migration of professionals. It is important to note that in these systems, though, that there is family immigration still exists in there, but a lot of them tend to be coming with the workers. So a lot of them are coming with them, and that sort of forms I guess you can say, a continuation of family migration for them, but it's not the pure family sponsorship that we have in the U.S.
I understand.
So some Senate Republicans rolled out the RAISE Act at the White House a few weeks ago. What would that bill do in terms of changes to our current immigration system?
So the RAISE Act was basically introduced as a way of introducing and reforming the U.S. immigration system as a merit-based system by introducing a range of, once again, similar points for qualifications for individuals. The important thing to understand about the RAISE Act, though, is that it also introduces pretty severe cuts to family sponsorship and immigration. The whole idea is that we're going to be bringing in the best and the brightest into this country, while the assumption is that we're going to be limiting family migrants that are seen as low-skilled or medium-skilled. So that's like the whole idea behind what the RAISE Act intends to do, or at least what the premises are.
Okay.
But I think one thing to know about that, though, is that what people tend to miss when they're talking about the RAISE Act is that Canada and Australia actually use these systems to boost the number of immigrants, whereas the RAISE Act actually wants to reduce the number of immigrants. And I think that's really important to understand what the RAISE Act intends to do, which is to limit the number of immigrants, largely on the assumption that more immigrants is bad for the American economy.
Great. Thanks, Cris.
And that's all for this week. If you liked what you heard, or you want to hear us discuss a specific topic in a future episode, please let us know. You can find us on Facebook by searching Bipartisan Policy Center, or on Twitter at BPC_bipartisan.
And don't forget to subscribe to this podcast, as well as all of BPC's podcasts, on iTunes by searching Bipartisan Policy Center. Join us again next week.